Welcome everybody to today's Smart and Bigger webinar. We're glad that you're able to join us in spite of the ongoing pandemic. Sit back, relax, and hopefully we can take your mind off what's going on in the outside world for a little while. Canadian trademark law was overhauled last June. In our webinar today, we will focus upon the most significant of those changes and discuss some of the consequences, both expected and unexpected. Since the overhaul in our law, there have been some unusual surprises. We'll share our insights with you and help you avoid some unexpected pitfalls. My name is Philip Lappin. I'm a partner here at Smart Biggar in our Ottawa office. I'm joined by Quan Lowe, who is counsel in our Vancouver office. I'm also joined by Jamie Lynn Kraft, who is a senior associate in our Ottawa office. We are all experienced trademark agents and trademark lawyers with a combined many decades of extensive trademark experience. In today's webinar, we will cover a broad range of topics. If at any point during our talk you have a question, do not hesitate to write your question to us in the chat box. We will be happy to answer all your questions towards the end of this presentation. If we do not have enough time to answer all your questions during our talk, we will be happy to follow up with you by email after our talk. And I should also mention that after our talk, you should be receiving an email, which will include a copy of these slides and will also provide a survey. So who are we? Well, we are all members of two firms, in fact, and two firms used to be called Smart & Biggar and Featherstone Haw, and both firms have existed for about 150 years. However, we learned that after 150 years, many of you still cannot pronounce Featherstone Haw. So we got rid of that name. There's still two firms, but they're both called Smart & Biggar. So that's easier for everybody. Smart & Biggar is the largest IP boutique in Canada. We handle anything related to IP, from procurement, so we can help with trademark registrations, patents, copyrights, industrial designs. We can help with any type of enforcement in any IP-related tribunal or court up to the Supreme Court of Canada. We help with any transactional matters, any kind of IP opinion work, and contract work. With that, I will now turn the stage over to Jamie Lynn.
Thank you, Philip. So the main focus of our webinar today, as Philip mentioned, is the changes to Canada's trademark law, which came into force last year on June 17th. We're going to talk about filing and prosecution strategy as well as enforcement strategy. So, the changes. These represented the most significant amendments to our Trademarks Act since 1950. The purpose was to modernize our regime and align Canada with international standards. We're going to talk today about how the law has changed and how it impacts you and your clients. So first, we're going to explore how you can leverage the changes to develop an efficient and cost-effective filing and prosecution strategy. Specifically, we're going to look at direct and Madrid filings, elimination of the use requirement, the new distinctiveness requirement, how to create market exclusivity by looking beyond the traditional trademark, and then we're going to share some unexpected traps and points of caution. So first, whether you're going to be filing directly or through Madrid, the NIS classification is now mandatory in Canada. And this applies to all new applications filed as of June 17th, 2019, all applications not published by June 17th, and all registrations upon renewal. It's worth noting that CIPO follows WIPO's guidelines for NIS classification rather than the USPTO guidelines, for example. So there can be some differences in classification in Canada compared to other jurisdictions, and therefore some surprises. And for those of you familiar with the examination process in Canada, you know that SIPO is very strict when it comes to the description of goods and services. This has not changed with the introduction of NIS. Goods and services must be specific and in ordinary commercial terms. That said, we typically don't recommend trying to be overly specific with the goods and services prior to filing. Broader protection can usually be secured by filing broadly and narrowing only if and when required by SIPO. The introduction of NIS also means the introduction of per-class filing and renewal fees, which Philip will address later in the webinar. But for now, we're going to move on to Madrid. As you no doubt have heard, Canada acceded to the Madrid Protocol last year. And this was great news for international brand owners because it allows them to easily designate Canada as part of an international registration. However, there are some drawbacks to using the Madrid system rather than filing directly. As would be the case in any jurisdiction, the Canadian rights are vulnerable to central attack. But there is an additional downside, which is uniquely Canadian. SIPO will not communicate with the non-Canadian agent appointed to represent the international registration before WIPO. So it's for this reason that we recommend appointing a Canadian agent to receive communication for the Canadian application. But what does that mean when I say that SIPO will not communicate with the non-Canadian agent? Well, this slide provides a helpful visual. It shows a sampling of the types of communication which SIPO will issue in respect of an application. So upon receiving the designation and noting that the applicant is represented by a non-Canadian agent before WIPO, SIPO will send one and only one letter to that agent. This is known as a courtesy letter, and it says, going forward, we will not communicate with you. We will only communicate with the applicant or a Canadian agent if one has been appointed. Of course, SIPO has an obligation to send certain correspondence to WIPO, and it will do so. However, as you can see from this chart, there are several pieces of important communication, some with deadlines, which do not get sent to WIPO and will only be sent to the applicant if you have not appointed a Canadian agent. So for example, a further examiner's report might be issued, and that would be the case when the examiner is maintaining the initial objections which were raised in the total provisional refusal, or what we call the first examiner's report. That report will have a deadline to respond, otherwise the application will be deemed abandoned. SIPO will not send that further report to WIPO, only to the applicant or a Canadian agent. So if the applicant has appointed a non-Canadian agent to handle the international registration, they might not be expecting to receive that correspondence from SIPO, nor process and forwarded it to their agent in a timely manner. To avoid SIPO communicating directly with the applicant if that is undesirable, and to ensure that non-Canadian agents do not miss any important correspondence or deadlines, we recommend appointing a Canadian agent for the Canadian application as soon as you receive that courtesy letter. And I will now turn the microphone back over to Philip.
Thanks, Jamie Lynn. So with the overhaul of our trademark system last June, there were literally hundreds of changes. And of course, we're not going to bore you with all of the hundreds of changes. We're going to focus on the changes that are most important to you. In particular, right now, I'm going to talk about two of the changes that are quite significant. One is the elimination of use in trademark applications and registrations. And second, I'm going to talk about a new type of objection that the Trademarks Office can now raise. So among the hundreds of changes to our trademark law, perhaps the one that's most obvious to everybody is now when you file an application or when you look at a registration, there's no more use information. So the obvious question that everybody raises is use still relevant? Well, use is still fundamentally important to Canadian trademark law and practice. I'm having trouble with my slides here. There we go. And I'll give you two examples as to how use remains fundamentally important, even though you no longer have any reference to use in trademark applications. And just to make this clear, before the law changed, when you filed an application, you would have to either indicate whether your application was based on proposed use or prior use in Canada or based on a home registration. And now none of that appears. Now you simply provide the applicant details, you show the trademark, you list the goods and services, and if there's priority, you mention that. But that's it, so no reference to use. So how is use still relevant in Canada? Well, if there's a fight between two trademark owners and the marks are found to be confusing, the winning party will be the party who has the earlier rights. And earlier rights are either based upon a registration or reputation. In other words, common law rights. So in Canada, there are two types of rights you can use to enforce your trademarks. One, registrations. Number two, common law. So if you can establish a reputation, you can establish your rights. Now, we always still recommend obtaining a trademark registration because it's much easier, faster, and typically cheaper to enforce your rights with a trademark registration. You can use it as a sword or a shield. So it's easier with a registration, but you don't have to have a registration. So that's the first example of how use remains fundamentally important. A second example of how use remains important is when you have a registration, if it's at least 3 years old, anybody can initiate a non-use cancellation proceeding, which we also sometimes refer to as a Section 45 proceeding. And once a Section 45 proceeding is initiated, the owner of the registration must prove use of the mark in Canada within the preceding 3 years. So use remains very important. So let's now look at a new type of objection that the Trademarks Office can raise as of last June. The objection is that a mark is not inherently distinctive. Now, although you can't tell from looking at me, many of my colleagues have pulled out their hair because they become so frustrated by the Trademarks Office. The Trademarks Office has been raising this objection in a huge percentage of cases where it's not warranted. And there's a significant problem at the Trademarks Office now because examiners have never had to consider this issue. And unfortunately, they don't understand the issue as well as they should. We've been told that the Trademarks Office is undergoing a huge effort to educate its examiners so we see fewer inappropriate objections based on a mark being not inherently distinctive, but we're still struggling at the moment. In any case, the Trademarks Office has published a practice notice in which it has listed different types of examples when it can and should legitimately raise this type of objection. And I'm going to go through some of them. If your trademark is a well-known place like London or Tokyo or New York City or Toronto, the Trademarks Office will object that the mark lacks inherent distinctiveness regardless of the goods and services. If your trademark is a design or a logo that shows what you're selling, or shows something that relates to what you're selling. So for example, if you're selling dog food and your trademark is a photograph of a dog or a simple drawing of a dog, you will receive this objection. If, however, you were able to raise Picasso from the dead, and if he painted you a cubist version of a dog, then that should not receive an objection. If your trademark is the name of a color, let's say white for printer paper. Printer paper is typically white, you can expect to receive this objection. But if your trademark, for example, were fuchsia for printer paper, fuchsia would be very unusual for printer paper, hopefully you would not receive this objection. If your trademark is a single letter, like the letter X or T or Q or V, in association with anything, you will receive this objection. Similarly, if your trademark is a number, you will receive this objection, regardless what you're selling. And the final example on this list is laudatory terms and phrases. Laudatory terms are terms which provide praise, like wonderful, world's best, terrific, healthy. All of these will almost certainly receive an objection. Now, there are other types of marks that will also receive objections. We're not going to go through all of them. In a few minutes, Kwan, however, will discuss the last bullet point on this slide. So what do you do if you receive an objection that your mark lacks inherent distinctiveness? Well, there are two main options for proceeding. As I mentioned at the outset, the Trademarks Office is raising this objection in many cases where the objection is not warranted and not appropriate. So you always have the option of arguing that the objection is inappropriate and should be withdrawn. And to date, I'm happy to say that the Trademarks Office has noticed in a few cases that it's made mistakes and has withdrawn the objection. So that's always an option. However, if the objection is warranted, then your only option is to file affidavit evidence of distinctiveness, or what the Americans refer to as secondary meaning. The evidence has to speak as of the Canadian filing date. Now, in Canada, we have 10 provinces and 3 territories. If you can establish secondary meaning or distinctiveness or a significant reputation in all 10 provinces and all 3 territories, then the objection will be withdrawn and you can obtain a registration across Canada. However, if your evidence only speaks to, let's say, a couple of provinces, perhaps Ontario and Quebec, then your registration will be limited to the provinces of Ontario and Quebec. Now, there's another option for dealing with objections, and this can apply to any kind of objection that only relates to a subset of your goods and services. The objections could relate to the description of goods, it could relate to distinctiveness, it could be descriptiveness, it could be a confusion objection. So let's say, for example, there's your trademark is healthy, the word healthy for food and clothing. Now, you're not going to be able to overcome or easily overcome the objection to food because healthy is descriptive of food, but you should be able to overcome the objection to clothing. So one option is to divide your application. So you would be left with one application for clothing and one for food. You could quickly obtain a registration for clothing and then continue to fight with the Trademarks Office for the food. And this is helpful because many clients are very eager to quickly obtain a registration, even if it's only for a subset of the goods and services. And it's important to note too that you can divide an application at any time while it's pending. So you can divide during prosecution if an objection only relates to a subset of the goods and services. And you can also divide in an opposition if the opponent is only objecting to a subset of your goods or services. So with that, I will now turn the mic over to Quan.
Thanks, Philip. Creating exclusivity in the marketplace is a critical part of branding. As a result, brand owners should always be looking for ways to try and creatively carve out such exclusivity. Today, I will be discussing 2 approaches that can be taken. The first is non-traditional trademarks. The second is prohibited marks, which I view as something of a hidden gem. The concept of non-traditional marks is not new to Canadian practice. Under our previous trademark law, 3-dimensional marks, the shaping of goods or their containers or mode of packaging, sound marks, and color applied to the surface of a 3-dimensional object were all capable of being registered as trademarks in Canada. However, our new law explicitly provides for the registration of many additional types of non-traditional trademarks, including holograms, moving images, scents, taste, texture, color per se, and the positioning of a sign. Also, any mark comprising a combination of non-traditional marks may also be registrable in Canada. I would highlight that for scent, taste, and texture marks, physical specimens will not be accepted by the Trademarks Office. Instead, the mark must be described using words. As Philip mentioned earlier, under the new law, examiners of applications for non-traditional marks will, in most cases, request evidence of acquired distinctiveness in Canada. The evidence needs to establish that distinctiveness as of the Canadian filing date. Examiners will generally be looking for evidence of significant sales, marketing, and advertising of the mark in association with the claimed goods or services. I would highlight that for color marks, an applicant could benefit from providing evidence that it is educating the public, that the color is an indicator of source that points to it, and that nobody else is using the mark in this manner. As it remains to be seen how the Trademarks Office will examine non-traditional marks for confusion, brand owners could benefit from filing as soon as possible, before the register becomes crowded. Of course, bearing in mind the need for acquired distinctiveness as of the filing date. The second way of carving out market exclusivity that I'm discussing today is not new. However, it is unique to Canadian practice, and from my experience, it is sometimes overlooked as a way for foreign entities, specifically universities, to obtain powerful rights in Canada. As some of you may know, Canadian law provides for what we call prohibited marks. These marks can be divided into official marks, which we will not discuss today since they are restricted to Canadian entities, and university marks, which can be owned by non-Canadian entities. The key takeaway here is that prohibited marks, including university marks, can be many of the things that regular trademarks cannot be. They can be confusing with a regular trademark that already exists on the register. They can be descriptive. They can lack inherent distinctiveness. So that entire list of possible objections that Philip mentioned earlier, not a problem. They can be geographic terms, and they can be a surname. So basically, if you think about all of the annoying objections that you have seen us report to you, university marks can be all of those things. And that's not all. A university mark can be cited by an examiner against a later filed regular trademark application. If the applicant is unable to overcome the objection through argument, then the consent of the university mark holder will be the only way to overcome the objection. Also, university mark holders are able to rely on their marks to oppose a regular application for a similar mark. As a result, this can give holders of university marks immense power over the registration of regular trademarks. So now you're probably thinking, how does one go about obtaining a mark like this? Well, not surprisingly, university marks must be owned by a university. Otherwise, the only requirement is that the mark must be adopted and used prior to filing. When it comes to scope of coverage, university marks are not limited to goods or services, and none have to be included in the filing, which means no need to deal with objections to a description of goods and services. It also means that these marks are not limited to any field of trade. University marks are examined only for formal requirements, meaning prosecution often takes only 4 to 5 months. Because there is no substantive examination, university marks are often less expensive to obtain than a regular trademark registration. Given their power and exclusivity, there have been calls for these marks to be done away with. For now, however, they remain part of the Canadian trademark landscape and are well worth considering for your clients that are universities. And now, Philip will discuss some unexpected traps and points of caution.
Thanks, Quan. So we knew for a long time what our new law would look like. In fact, we knew our new law is based on the Trademarks Act and the Trademark Regulations. The Trademarks Act was actually passed 5 years before it was enforced, and Trademark Regulations were we knew what they looked like about a year before, maybe 6 months, but we didn't know how they would be implemented. And there were a few surprises to us and our clients, and some of those surprises were a bit shocking. So we're going to go through some of those, in particular, those related to fees and extensions of time. So before June of last year, Canada had no mandatory classification system. In fact, I believe we were the last country in the world to impose a mandatory classification system. Now, like every other country, when you file a trademark application in Canada, you pay per class. So that's nothing special. The fees are set out here. The fees, I think, are pretty reasonable in terms of global comparison to other countries. What is surprising, and in fact shocking, is how the Canadian Trademarks Office calculates fees. Let's pretend for a moment that we're not filing in Canada. Let's say we're filing in the States. And you file an application with a laundry list of goods and services, and eventually the USPTO says you have 10 classes and you have to pay for 10 classes. And you say, well, I don't want to pay for 10 classes, I only want to pay for 2 classes. So what you would do is you would cancel the 8 classes you don't care about and only pay for the 2 classes you do care about. This is not how Canada works. In Canada, let's say you file your same laundry list of goods and services with your application, and let's say the Trademarks Office decides, once again, there are 10 classes, and you think, well, I'll just delete the 8 classes I don't want to pay for. Well, you can delete the 8 classes, but you still have to pay for them. So that's what's surprising, and that's what everybody has to understand. You have to pay for every class of good and service that appears in your application as of the filing date, even if you subsequently delete the classes you don't care about. So if you're cost conscious, make sure you know how many classes are in your application when you file it. The same issue applies on renewal. And this is going to be more shocking to many people. As I mentioned, before June of last year, we had no mandatory classification system. So this means that virtually every registration that appears on the Canadian Register has not been classified. You do eventually have to classify your registrations. When do you have to classify them? Well, you only have to classify your registrations when you renew them, so that's fine. However, if you wait until the renewal deadline to classify, you have to pay for every class that appears in your registration. And keep in mind, old registrations, they're just a jumble of goods and services. It might not be obvious how many classes there are. Some people may have overclaimed. So you can have a very serious problem. So the Trademarks Office might decide you have 25 classes. And if you wait till the renewal deadline, you have to pay for 25 classes, and that can be exceptionally expensive. Now, there's an easy way to avoid this problem, and the way you avoid this problem is to make sure that you classify well before the renewal deadline. So we recommend classifying at least 6 months before the deadline, because it can take considerable time for the Trademarks Office to look at your proposed classification, and if they disagree with you, it can take some time fighting back and forth with the Trademarks Office. So we recommend classifying at least 6 months before the deadline. If there are more classes than you want to pay for, at that point you can delete the unwanted classes. The deadline, you only pay for the classes you want. So the moral here is classify before your renewal deadline to avoid unexpected and unpleasant surprises. One other area I'm going to talk to you briefly about where there's an unexpected change is with respect to extensions of time. So Canada used to be a very kind and friendly nation, and before June, whenever you received an office action, you could always get a 6-month extension of time. If there were 10 office actions, you could get 10 6-month extensions of time. Well, Canada is less kind and friendly now, and they changed the way they will grant extensions of time. And the new rules are a bit complicated, but in most cases, this is how it works. Throughout the life of your application, you are only entitled to a single 6-month extension of time. So if you get 10 office actions, you don't expect an extension of time with each office action. In general, you're only entitled to 1 extension of time throughout the entire life of your application. As I said, it's a bit complicated. The best way to proceed is to assume that the deadline is the deadline and that you cannot get an extension of time. Of course, whenever we report an office action, we'll let you know at that point if an extension of time is available. But don't assume you'll be able to automatically get an extension of time. It's not like the old days. So with that, I will now turn the stage back to Jamie Lynn.
Thanks, Philip. Yes, we're moving along to the next part of our webinar, where we are going to explore how you can leverage Canada's trademark law to develop an effective enforcement strategy. So specifically, we're going to look at the importance of monitoring, the new mechanism called the Notice of Third-Party Rights, and we will also discuss opposition and cancellation proceedings in Canada. Now, earlier in the webinar, Philip explained how use is no longer a prerequisite to registration. Even though use is still relevant in Canada, we nonetheless expect and have already seen an increase in troll applications. So by way of brief background, a trademark troll is someone who files applications without any intention to use the marks, and typically with the intention to extract payment from legitimate brand owners. Troll applications are troubling because they block applications by legitimate brand owners and decrease the distinctiveness of brand owners' marks. For this reason, brand owners should consider periodic monitoring of the trademarks register as well as the marketplace to catch these applications. This can be done at 2 stages. 1, monitoring newly filed applications gives you an opportunity to catch the trolls early. 2, monitoring published applications ensures that you are made aware of your window to oppose. One question you might be asking is, what can you do if you spot one of these troll applications early, besides sending a demand letter directly to the applicant? If the application is newly filed, it can't be opposed yet. Well, that's where the notice of third-party rights could come into play. The notice of third-party rights is similar to the letter of protest in the United States, and it's an informal way of bringing information relating to the registrability of a pending application to SIPO's attention, with the goal, ideally, that SIPO will block the application before it can even make it through to publication and opposition, essentially doing the work for you. There are only 3 permissible grounds which can be raised in a notice of third-party rights. 1, the mark is confusing with a registered trademark. 2, the applicant is not entitled to registration due to an earlier filed confusing mark. Or 3, the application lists a registered trademark in the description of goods and services. So you'll note that common law rights are irrelevant at this point, and SIPO will not consider arguments or evidence when reviewing these notices. Now, this is a mechanism which became available this past year when all the other changes came into force, but it's not a legislative change. It's a practice that SIPO put forward. SIPO therefore retains the right to eliminate this practice if it finds that it's being abused, such as by people filing evidence and arguments. But for now, it is available, and you should consider filing one when you identify a troll application early in the process. And now I'm going to turn the microphone back over to Kwan.
Thanks, Jamie Lynn. Despite the many changes to our law, opposition practice in Canada remains largely the same. However, there are a few changes worth noting that have already come into force. Most importantly, bad faith is now an explicitly available ground of opposition, so that should come in handy against trademark trolls. Also, electronic evidence can now be used. This has been a welcome and convenient change in many cases. We're also looking forward to some changes that have been passed into law but have not yet come into force. First, leave of the court will become required if a party wishes to introduce new evidence when appealing a decision of the opposition board to the federal court. Currently, no such leave is required. Second, it will become possible for the opposition board to award costs in opposition proceedings. Currently, cost awards are not available. At this time, we do not know when these changes will come into force. Under the new law, we anticipate that oppositions will be used more frequently by brand owners in Canada. This is due to an increase in the total number of applications filed due to our accession to the Madrid Protocol, as well as the removal of the use requirement to obtain a registration, meaning there are likely more troll applications, as Jamie Lynn has mentioned. However, the good thing is that Canadian oppositions remain relatively simple and inexpensive, particularly when compared to oppositions before the United States TTAB. In most cases, a Canadian opposition from start to finish will cost tens of thousands of dollars, which is a magnitude less than the cost of most opposition proceedings in the United States. Oppositions remain far less expensive and easier to manage than litigation, and it is better to prevent registration of a potentially conflicting mark rather than trying to seek its expungement before the court. As many of you know, in Canada, we have a process to keep the register clear of marks that are no longer being used, what we like to call deadwood. These proceedings are called non-use cancellation proceedings, or as Philip mentioned earlier, you might hear us refer to them as Section 45 proceedings, after the relevant section of the Trademarks Act. These proceedings are available against any registration that is more than 3 years old and may be commenced simply by writing to the Trademarks Office and paying the required fee. Once the relevant notice is issued by the office, the registrant must demonstrate use of the mark in Canada in the 3 years immediately prior to the notice, or provide acceptable reasons justifying the absence of use in Canada. One of the few changes to summary cancellation practice is that it is now possible to target specific goods or services in the proceeding. In other words, if a party is interested in having only some of the goods or services deleted or challenged in a registration, the registrant will be required to prove use of the mark in association with only those goods and services, which might help streamline some proceedings. Cancellation proceedings are meant to be summary in nature and focus only on whether there has been use of the mark during the relevant period in Canada. Any attack on a registered mark for substantive reasons, such as for descriptiveness, genericism, or a lack of distinctiveness, must instead be brought before the federal court. As a result, only the registrant is able to file evidence in a cancellation proceeding. The party initiating the proceeding, known as the requesting party, cannot file evidence. In addition, the registrant only needs to provide evidence of a single bona fide instance of use of the mark in Canada during the relevant period. An evidentiary overkill is simply not required. Furthermore, the requesting party cannot cross-examine on the registrant's evidence. Written and oral arguments are optional. As with oppositions, the decision in a cancellation proceeding may be appealed as of right to the federal court. Given the limited number of steps involved, cancellation proceedings move quite quickly. When a registrant does not file evidence of use, it is usually possible to have a registration expunged in about 5 to 6 months from start to finish. Now, cancellation proceedings can also serve as a tool to overcome a confusion objection based on a registered mark. Given that canceling a cited registration will certainly overcome a confusion objection, and given that the cost of an uncontested cancellation proceeding can in some instances be less than the cost of filing comprehensive written arguments for which there is no guarantee of success, cancellation proceedings can sometimes be the best way to proceed against a cited registration, including registrations based on troll applications. Because of the number of troll applications that have and will proceed to registration in Canada, we anticipate that brand owners will have to utilize cancellation proceedings more than ever. The good thing is that they tend to be relatively straightforward and inexpensive. On the other hand, it is important for brand owners to recognize that for any defensive registrations they may have obtained for which there is no use of the mark in Canada, such registrations will be prone to cancellation once 3 years have elapsed from the registration date. As a result, Despite the absence of a use requirement to obtain a registration, it remains very important for brand owners to use their registered trademarks in Canada. And that concludes the slides that we've prepared for today's presentation. We'll now take a look at some of the questions that have been submitted by the audience.
Thanks, Juan. So we do have a number of very good questions. Feel free to ask further questions. We're going to make our best effort to answer all of your questions. So I am going to read the questions and then I'm going to direct them to the person who I think is probably best able to, or perhaps not best able to, but who has addressed the issues peripherally, at least during the talk. So this first question appears to be aimed at Jamie Lynn. The question is, if the applicant is an American, will SIPO write to them?
Thanks, Philip. I assume this question is in the context of a Madrid filing, so a Canadian designation which has been made by an American. So if the applicant is American and they haven't appointed even if they have appointed a non-Canadian agent, yes, SIPO will write to the American applicant. I hope that answers the question correctly.
So let's say, Jamie Lynn, it's not a Madrid application. Let's say it's just a regular application. What happens?
Oh, if it's a regular application and no Canadian agent has been appointed, then SIPO will communicate directly with the applicant.
Okay, so this next question appears to be a related question, also directed to you, Jamie Lynn. So here's the question. With respect to communication with a foreign applicant, the Act requires a legal representative for service if the applicant doesn't have a Canadian address. Any thoughts on the implications of that in the absence of a Canadian agent? I am imagining a vacuum, except for a letter notifying the applicant of the rep for service / address requirement.
Now, I might be getting a bit confused. There used to be a requirement under, and Philip, feel free to jump in here and correct me, because I didn't look at this specific issue in depth before the presentation. But before the change in the law, it was necessary for applicants to have a representative for service located in Canada in order to receive correspondence. That requirement no longer exists under the new Act. So if there is, I believe an applicant will communicate directly with SIPO, even if they are from a foreign jurisdiction. Philip, feel free to jump in if you disagree.
Right, so there's no more, so Jamie is correct. So there's no more concept of a representative for service in Canada. There's only an agent. If the applicant applies directly, it's the same as in the Madrid context. The Canadian Trademarks Office will write directly to the applicant. They will not write to any foreign representative or agent. And so I think that does answer the question. Thanks, Jamie Lynn. So for this next one, I'm not sure who's control the slides. Michael, I'd appreciate if you could turn to slide 15, please. I think that's what this question relates to. We'll just wait for the slides to go back. So this related to the issue of the new objections related to not inherently distinctive marks. So let us go back to some examples of not inherently distinctive marks. So the question is it possible to disclaim such terms? So an objection that a mark is not inherently distinctive will only apply if the mark as a whole lacks distinctiveness. So let's look at the first example. So the first example here is the mark is London, and for anything at all, let's say for dog food, you'll get the objection. If the mark is only London, you could disclaim the term, but you wouldn't be left with anything. In Canada, disclaimers used to have some significance. Now they do not. You can disclaim anything you want, but it will have no implications in terms of examination. So if you receive an objection, you can disclaim whatever you want. It will have no impact. You cannot overcome any objection by including a disclaimer, unfortunately. The only objection is if you can think of the Canadian flag, there's an 11-pointed maple leaf. There's a specific provision not allowing anybody to have a monopoly over the 11-pointed maple leaf. You have to include a disclaimer of the maple leaf. But that's the only time throughout all of Canadian trademark prosecution where you are required to provide a disclaimer. It's the only time where it has any impact. So the next question is, it seems as though the delineation between clearly descriptive and insufficiently distinctive is rather murky. What's the difference? Or have some of the traditional descriptiveness objections simply been recategorized as a lack of distinctiveness, such as laudatory marks? Okay, so that's a good question. So before June, the Trademarks Office could always object that a mark was clearly descriptive. So the example I gave was healthy for dog food. That objection still exists. So let's say your mark is healthy for dog food. You will continue to get an objection that the mark is clearly descriptive of a characteristic of the goods. In addition, you will also now obtain an objection that the mark lacks inherent distinctiveness. So you'll get both objections. So if we look at the next slide, if I have control. Yes, I do. So if your mark is clearly descriptive, you get both objections. Your mark is descriptive and it lacks inherent distinctiveness. If your mark is primarily merely a surname, like Smith, you will receive an objection that your mark is primarily merely a surname. You will also get an objection that your mark lacks inherent distinctiveness. So there's now an additional objection. So you will get both. So the life of a trademark practitioner is now harder because there are additional objections. No objections have been removed. Next question relates to, let me go back to, here we go. If you get an objection that your mark lacks inherent distinctiveness, I mentioned that one option is to file evidence of distinctiveness or secondary meaning as of the Canadian filing date. And I said that if your evidence does not cover all of Canada, so if you haven't proven a significant reputation in all provinces, I said your mark would be limited, your registration would be limited to those provinces where you provide a reputation. So the question is, if you receive a registration that is only for several provinces or territories, will that be shown on the registration certificate? And the answer is yes. You have to look at it. It won't be highlighted and it won't be flashing, but there will be a description section that says that the registration is limited to whichever provinces or territories that where you've proven distinctiveness. The next question relates to divisional applications. So I mentioned that whenever you receive an objection during prosecution, or if you're in an opposition where either the Trademarks Office or the opponent is only concerned about a subset of the goods and services, you can divide your application. So here's the question. Is there a fee for dividing an application? So the answer is no. So in fact, let's say you have 100 goods and services. You can file 100 divisional applications. There is no government fee. And then the question goes on, just wondering if we can save filing fees by filing one application with multiple classes as opposed to two applications, dividing up the classes, since the first class is $330 and the subsequent classes are $100 each. That's kind of an interesting question. So you can divide at any time. So you can file, to get a filing date, you only need to pay one class fee. So let's say you have 100 classes, you pay for one class fee, you get a filing date. The second day, you can divide your application, let's say, into 100 parts. Now, the first class is $330. Each additional class is $100. So you're going to have to pay for all of the classes regardless when you divide. So the government fee will be $330 plus 100 times the number of classes you have beyond one. So you can't save any fees by dividing. The government fees will be identical regardless when you divide. I think I've answered your question, but if I haven't, please feel free to follow up. Okay, the next question is directed to Kwan. Here's the question. Can a trademark owner negotiate an agreement with a university to have the university own the trademark and grant an exclusive license to the original owner, permitting the, quote, easy, quote, registration process?
Thanks, Philip. That's a really interesting question, and Philip or Jamie Lynn, feel free to jump in with your thoughts. I think that would be a very tricky situation. The questions that come to mind are, is it possible to have that license in place? It would presumably covers some goods and services, which a prohibited or university mark would not. My recollection is the case law hasn't finally decided whether it's possible to do something like this. So I think it's a real question mark. It's a great thought, but off the top of my head, I'm not sure I know for sure whether the answer would be yes or no.
Okay, thanks, Kwan.
I have one minor comment to make on that point. I think that you want to be wary of the fact that a university mark is not, unlike a trademark registration, which says you have the exclusive right to use this. A university mark does not provide that same right, so it might not have the same value in a license that a trademark registration would.
Yeah, so that's a good point. So a university mark or an official mark is it's a sword, it's not a shield. So a trademark registration is both. So a trademark registration, you can assert your rights to sue somebody, and if somebody attacks you, it's a defense to infringement. An official mark or university mark only prevents someone else from using their mark. It's not a defense to infringement too. So there are lots of issues with that. I wouldn't recommend it to a client, but it's an interesting question.
That's right, and that's a really good point, Philip, because we know that there's been recent case law where a party tried to rely on a prohibited mark as a defense to infringement, and the court decided that their claim was no good, that having a prohibited mark is not defense to infringement. So that's a really excellent point to keep in mind as well.
Thanks, Kwan. So this next question is directed to Jamie Lynn. Here's the question. I have a question concerning an international trademark registration designating Canada. We received a courtesy letter from the Canadian Intellectual Property Office informing us that any future correspondence regarding the case will be sent directly to the applicant or to the appointed Canadian trademark agent. Considering that provisional refusals of protection are sent to WIPO, which notifies the refusal to the appointed agent of the international registration, which are the documents that will be directly sent to the applicant in the absence of an appointed Canadian trademark agent?
That's a great question, and I usually, when I get that question, I usually also get the question, well, why can't I wait until I get the total provisional refusal before appointing a Canadian agent? Because I'll know about it at that point, because WIPO will be informed, and then they will inform me, the non-Canadian agent. Well, there are some communications which CIPO can send in respect of an application before and instead of a total provisional refusal, and which it will not send to WIPO. So these include approval notices. So despite the fact that there are many objections in Canada, sometimes it is the case that an application will be approved without any objections. That approval notice, it's an important one. It should be reviewed prior to the mark being published for opposition purposes to ensure there's no errors. And that's something that a Canadian agent can do, and they can do in a timely manner. And if you have not appointed a Canadian agent, you won't have the benefit of the non-Canadian agent receiving that approval notice directly or in a timely manner. And other examples could include, I spoke about a notice of third-party rights. Let's say someone has filed a notice of third-party rights against your client's application prior to examination, prior to a total provisional refusal. That's something that doesn't get sent to WIPO, but would be sent to the Canadian agent if one was appointed. That's something that you might want to know about. So those are some examples.
Thanks, Jamie Lynn. The next question is a question we see a lot. I'll read it. Does CIPO plan to examine marks quicker? It's getting ridiculously long in terms of timeline, around 30 months now. So we agree with you. It is ridiculous. So the time to examination now, so once you file an application until it's examined, is getting close to 2 years. And so before the pandemic, it was around 22 months. I think now it's probably around 2 years. That is too long. So the time to registration, so you're probably correct, is probably around 30 to 36 months now. It's too long. The Trademarks Office acknowledges that it's too long. Over the past year, And over the next from a year ago to the next 6 months, they plan to, I believe, almost double the number of examiners. They're trying to hire more qualified people who hopefully should learn faster and have a better understanding of trademark fundamentals. The idea is that the quality of examination will improve and the timeliness will improve. I believe they hope to have examination times down by more than half in about a year to 2 years. So it's going to be slow and painful for the next year or two, but then it should become significantly better. But for the moment, I agree with you. We're all suffering, unfortunately. Next question. So this relates to the topic I mentioned before, where you receive an objection that your mark lacks inherent distinctiveness. You file evidence of distinctiveness, but it's only limited to certain provinces. So then your registration is limited to certain provinces. Here's the question. If you are using a partial registration that is limited to certain provinces, could it be considered when enforcing the mark in an adjacent province? Okay, so the default in Canada is that your registration covers all of Canada. The exception is a case like this where your mark lacks inherent distinctiveness, where you're limited to the provinces where you can establish distinctiveness. So in that case, your registration only applies to the provinces that are listed in your registration. So if you're using a partial registration only in some provinces, could it be considered when enforcing a mark in an adjacent province? So the answer is, well, you can use whatever you want, but the question, I guess, really is it going to help you? And the answer is no. So the registration will be limited to those provinces where it's listed as applying. If you want to enforce your rights in an adjacent province without a registration, then you have to rely on your common law rights, which means you would have to establish a reputation in that adjacent province prior to any relevant date. And if you don't have a reputation and your registration doesn't include that province, then you're out of luck. The next question is a related question. When the examiner raises a question of distinctiveness, what is the time frame that you must show the mark has become distinctive? Is it from the date of the examiner's report or the date of filing of the application? So the relevant date for proving distinctiveness is your filing date of the Canadian application. So it doesn't matter when the office action issues, you have to show distinctiveness as of the Canadian filing date. And so increasingly when clients are coming to us asking us about whether or not they should file marks that might be considered to be lacking in inherent distinctiveness, we always warn them that if we get an objection and we can't successfully argue against it, in other words, if we can't convince the office that there's some inherent distinctiveness, then the applicant will have to be able to establish secondary meaning as of the Canadian filing date. So the next question is for Quan. Apart from a non-use cancellation, is there a provision for cancellation, I guess canceling on the grounds of bad faith adoption?
Thanks, Philip. So if I understand the question correctly, is there any other way to get rid of or cancel a registration based on bad faith? So the first option would have been to oppose before the application proceeded to registration on the basis of a bad faith filing. And the other option, if the application has already proceeded to registration, I believe the Trademarks Act has now been revised so that you can go to federal court and seek expungement on the basis that the application was filed in bad faith.
Thanks, Quan. So we're running up to the end of the hour. I think what we'll do is we have a few more questions. I think we have about 4 or 5. While we have you here, we'll answer all your questions. But of course, if you have other obligations, we won't hold it against you if you want to leave now. And if for whatever reason we have not answered your questions during our call, feel free to email us and we'll email you back. And if we have forgotten to answer any of your questions, we will look through our questions again and we will email the answers to you, assuming we can find you. Okay, so we have a few more questions. As I say, I think we'll probably go for another maybe 5 to 10 minutes. Let's see. Okay. So this next one is also directed to Quan. Here, the question is there any difference between a non-use cancellation proceeding and an expungement proceeding. The terms appear to be used interchangeably.
Thanks, Philip. The terms are used interchangeably, so strictly speaking, an expungement proceeding would be to expunge a trademark registration for any number of reasons. So what we usually say is, when we say non-use cancellation proceeding, we usually refer to the Section 45 proceeding or the summary cancellation proceeding, which is the other term, which strictly relates to the use of the mark and is before the Trademarks Office, as opposed to an expungement proceeding before the federal court, where there can be other grounds for expunging a registration.
Thanks, Quan. The next question, I will answer. I'm not sure who it's directed to. Here's the question. If an applicant files a broad term, such as beverages, that CIPO considers vague and requires narrowing, will CIPO require the applicant to pay for all possible classes in which various types of beverages, alcohol, beer, carbonated, etc., may fall? So this is a very good question. So in order to get a filing date, you only need to pay for one class. So that's $330. After that, the Trademarks Office will examine the application and determine how many classes there are. Only once the Trademarks Office has determined the number of classes do you have to pay for the classes. Now, beverages is not acceptable in Canada, as probably any of you who have filed any applications in Canada know. Canada is ridiculously picky in terms of the required specification. In many cases, the Canadian office requires even more specificity than the US. So if you file an application with beverages, you will receive an objection that the description is too broad. You'll have to specify it. Only once you specify it will the Trademarks Office determine how many classes it falls into. So you only have to pay for the number of classes of the redefined term. So if you say beverages, namely milk, you only have to pay for one class. If you want to say beverages, namely milk and beer, that's two classes, then you'd have to pay for two classes. So it depends how you redefine the terms, and you only have to pay once the Trademarks Office has accepted the redefined terms and you and the office have agreed how many classes there are. So you don't have to pay for upfront for every possible class that your initial description falls into. So here's a question for Jamie Lynn. For an international registration designating Canada, can we appoint a local agent as soon as WIPO formally registers a mark?
You absolutely, you can appoint a Canadian agent basically as soon as you have a Canadian application number. So, and it's as simple as writing to your agent of choice in Canada, telling them the Canadian application number, and then they'll write to the Canadian Trademarks Office for the appointment. Even if you don't know the Canadian application yet, you can write to your Canadian agent with the international registration number, and then your Canadian agent can monitor the Canadian database for when it shows the Canadian application number and make the appointment at that time.
Thanks, Jamie Lynn. We have a few questions about CLE credits. So there's nothing official about this presentation. For people in Ontario, for example, you can get one substantive hour. In other jurisdictions, we don't know, but there's nothing formal, no formal CLE credits have been provided with this presentation other than what you get for viewing any substantive content about IP. Here's a question I think is directed to me. In the event that a trademark application of a 3D shape, for example, is rejected on the grounds of inherent distinctiveness, could an applicant overcome this by providing satisfactory evidence that the purchasing public associated or have long associated that specific shape as having originated from the trademark owner? So, so the answer is yes. So when there's an objection that a mark lacks inherent distinctiveness, another way of framing the objection is the mark does not function as a trademark. In other words, it does not point to a single source. In order to overcome the objection, you need to file evidence of distinctiveness. And what distinctiveness means is that the public perceives it as pointing to a single source. So if you can convince the Trademarks Office that when the members of the public see your 3D mark, and you can convince the Trademarks Office that the public believes that this 3D mark is associated with a particular company, then that satisfies the evidence of distinctiveness, and you should be able to overcome the objection. The next question. So you have an objection based on inherent distinctiveness. You've only proven distinctiveness in a couple of provinces. You get a registration for a couple of provinces. The question is, can you ever expand the amount of provinces that are covered? The answer is yes. So you can do that. It's what you have to do is essentially file a new, what we call an extension application. It goes through the same application process. You would prove that you have distinctiveness in whatever additional jurisdictions in Canada that you want to add to your registration. Next question, it relates to proving acquired distinctiveness once again. In establishing acquired distinctiveness, what evidence tends to be more probative? Is social media evidence, e.g. numbers of followers from Canada, given much weight? So it's very hard to prove distinctiveness. And typically you can provide evidence of number of followers from Canada, but unless it's massive, it's not going to be that compelling. What the Trademarks Office really wants to see typically are huge sales of evidence of sales, marketing, and advertising. What you can do as well is if you have the pockets, the deep pockets to provide a survey, that would be useful. If you can provide evidence from your target market, affidavits from your suppliers or your retailers or your consumers that they view the mark as distinctive, that would help. But simply showing, for example, that you have a website accessible in Canada or that you have a Facebook page that has been viewed in Canada is typically not enough. You really need to show that a significant percentage of your target market has been exposed to your mark. There's no set format to do that, and there's no, in some countries, if you can show sales, for example, for let's say 5 years, there'll be an assumption or an inference that your mark is distinctive. That's not the case in Canada. You need to show big numbers for a sufficient period of time, and it's all left to the discretion of the trademark examiner. So it can be a very frustrating process. The best thing to do is ask whoever you're working with in Canada, tell them what kind of evidence you have, and they can give you their view as to whether or not that will be sufficient. And we just have a couple more questions. Oh, that's it, actually. So I believe we have answered all the questions. However, we will review the questions again after the webinar. And if we've missed any of the questions, we will go back and we will write to you, assuming we have your email address. We want to thank everybody for spending your time with us today. We've enjoyed it, and we hope you have too. Thanks very much. Have a good day. Bye.
Bye.